You know, the digital world is completely rewriting the rules of law, and it's starting with one of the most basic ideas, the Declaration of Will. This explainer is going to dive into that evolution, and it's based on the works of Professor Vihar Kiskanov. We're going to see how a simple mouse click can now have the very same legal weight as a handwritten signature. So here's our roadmap. We'll kick things off with our new digital reality, then take a step back to trace the historical roots of this whole concept. We'll see why the old definitions just don't cut it anymore. Then we get to the real heart of the matter, the split between will and declaration, before we look at some real-world examples and peek into our automated legal future. All right, let's start with the world we're all living in right now, a new digital reality. To really get a handle on the legal changes, you first have to understand the massive practical shift, from a world of paper and being physically present to one that's all about electronic systems and automation. In this table right here, it really gets to the heart of it. Traditionally, only people, what the law calls legal subjects, could do things that were legally binding. But in this new virtual world, a whole new actor has shown up on stage: information technology. Software can now record data, it can form declarations, and it can create legal acts all by itself. This isn't just about changing from paper to a screen. It's a fundamental change in who or what can legally act for us. But, this new reality didn't just pop up out of nowhere. To really appreciate how big this shift is, we need to go back in time and look at the historical roots of this concept. We need to understand the foundation that all this new technology is now challenging. So this whole idea of a legal declaration of will, it wasn't always a thing. If you look at Roman law, they didn't really have a single neat concept for it. It really started to take shape back in the 17th and 18th centuries, mostly connected to business deals. By the 19th century, legal thinkers were obsessed with the link between a person's inner thoughts, their will, and how they expressed it outwardly. And at the same time, in public law, you get this huge idea that the law itself is an expression of the general will of the people. And this idea is captured perfectly by the 19th century jurist Winscheid. He said, "Law is the power of the will." What he meant was that, at its very core, a legal act had to come from a conscious, deliberate, and uniquely human choice. This human-centered view became the bedrock, the absolute foundation of legal theory for more than 100 years. But as we're starting to see, that bedrock is beginning to crack under the weight of technology. So let's look at exactly why those old human-centric definitions are just failing us in the modern digital world. The classic way of thinking, summed up right here, was that making a legal declaration was something only reasonable human beings could do. The thought and the action, they were seen as two sides of the same coin, completely inseparable from a person. The problem, of course, is that reality has just completely zoomed past this theory. I mean, think about it. What about automated notices in public procurement? Or all those little procedural declarations in an administrative process? These things have real legal consequences, but they don't fit that old model of a person consciously making a decision in that exact moment. Our digital world is now filled with these legally important acts that aren't directly made by a human. And this brings us to the absolute core idea, the big conceptual breakthrough we need to understand modern law. We have to separate the internal will from the external declaration, because in the digital age, they are definitely not one and the same anymore. Okay, so first, the classic model. It's really simple. The person who has the intention, the internal will, is the exact same person who speaks, writes, or signs to make that external declaration. The source of the will and the source of the declaration, identical. Now check this out. Here's the game-changing shift. In the modern view, the source of the will is always human. That doesn't change. But the source of the declaration, well, that can be a person or a piece of technology. A human sets the rules and the intention, and then a machine carries it out, creating declarations when needed. That direct link is broken. So what does this human will actually look like then? Modern law breaks it down into three parts. First, there's the will to act, which is the conscious physical act like clicking a mouse. Second is the awareness of declaration, which means you know that click has some legal meaning. And third, the transaction will, which is your intent to get a specific result, like buying a book. It's by identifying these human elements that the law can trace an automated declaration all the way back to a person's original intent. And you can actually see different legal systems trying to figure this out in real time. In the US, for example, they use the idea of an electronic agent. It's kind of a legal fiction where the machine's actions are treated as if you did them yourself. Germany, on the other hand, sees the computer as just a declaration tool. It's no different than a pen or a rubber stamp. The machine is just an instrument. The human is still the one and only source of the will. Now, these different legal ideas aren't just for dusty law books. They have huge, real-world consequences. So let's take a look at how this new way of thinking about will and declaration is shaking up different areas of law in our digital age. I mean, this stuff is everywhere. It's in those click-wrap agreements you accept online and in self-executing smart contracts on the blockchain. It's in e-government systems that automatically issue administrative decisions. It even touches our constitutional rights with things like digital identity wallets and the debate over e-voting. Even really traditional areas like inheritance law are now grappling with electronic wills and digital assets. And hey, every time you use your face or fingerprint to pay for something, you're making a legally binding declaration of will using technology.
So let's pull all these different threads together and think about what this all means for our automated legal future.
The key takeaways from Professor Kiskinev's analysis are pretty clear. First, the law isn't stuck on paper and ink. The physical environment doesn't really matter. Second, and this is a big one, the law already accepts declarations that are made without a person being directly involved in that specific moment. And third, this team-up, this combination of a human will and a technological declaration is a totally valid way to create legal effects. To help manage all this complexity, modern legal thinking actually distinguishes between different kinds of declarations. For instance, an electronic declaration might be an email you physically type and send. An automatic one could be a stock trade you scheduled last week. And a computer declaration might be one generated by an AI all on its own in response to new data. Each term just reflects a different level of automation and human involvement.
And that leaves us with one final and really important question. We've established that machines can legally speak for us based on an intention we expressed at some point in the past. But as these systems get smarter, more complex, and more autonomous, how do we make sure that their declarations are still reflecting what we actually want? How do we ensure our true will is still being served? Now that is the challenge for the next chapter of law in our information society.